Thank you, Your Honor. I was on
now the investigating officer for the court will tell us that.
one, to allow the police or the DCI to conduct investigations in a manner that they would want. That was granted. Two, to preserve the subject matter. Who is the respondent in this matter? That in the event the DPP decides to exercise Article 157 and charge her, she's within the jurisdiction of this court. Conditions as bail, conditions as deposit of passports, conditions of reporting to the police are the constitutional instruments granted to the court to ensure that the respondent cannot move out of jurisdiction. You know, you are being told now, close this file. The investigating officer has not disclosed the recommendation to the DPP. If the DPP decides to charge and the respondent is out of the country, we shall be in a position of absurdity. And this is the first time in the history of criminal justice system, the state is saying, close the miscellaneous without offering that we are not going to charge. Or close the miscellaneous because here is a charge sheet. That is, by experience, what the family expected. The state is allowing a Sahara-like situation go. What is the actual position of the respondent? The DPP has confirmed they have received the file. What prejudice does this miscellaneous file occasion that it warrants closure? I've been a matter for KRA for the last 3 years. Still, we are running the miscellaneous application pending the determination of the DPP to decide. So this, Your Honor, is strange. And to me, it is a setup that the court has released this person. It is the court that releases. That is why they came to you, asked for orders to detain or allow to investigation, and they are before you to release her and close the file. I'm alive to the reality that this is not somebody who has been charged. The state could have gone through 87A to close. It's provided by law. It is section 87A. This that has been made to you, Your Honor, let it be put to you under the National Police Service Act. Which section? or under the DPP Act, which section? Or under the CPC, which section? Under 157, which section of the law will allow closure without a definite certain angle to take? What do I tell the family of the deceased? What do we tell Kenyans who are interested in this matter? On a third angle, the purpose of the miscellaneous application is to keep the DPP within timelines. This file can go to the DPP and stay there for 30 years. The office of the DPP will turn into a parking lot. How will my clients follow? Unless now I'm restricted to move to the private prosecution. If this file is kept alive for the purpose of the DPP, and because the file is there to give the court the update. We are at this stage, we need this time. We have reached this type of investigation, we need this time. That is another reason as to why anybody, Your Honor, who appears before you is your one. She's no longer a person of the police. She's no longer a person of the DPP. She is before you. You have the judicial authority to supervise. You are being excluded. The judiciary is totally being excluded from a very critical question. The supervision of the DPP and the DCI in this matter on behalf of the victims. You know, it is my submission that you deny the application for closure of this file. We take a mention date for the DPP to come and tell us the decision they have made. And the strike law that nobody can challenge the DPP, whichever decision they come with. But out of that decision, we'll be able to know whether we'll go for private prosecution or we'll go for murder trial, or we'll know what is happening. You know, kindly don't allow the family and the whole country to be kept in the darkness. But this file now will be left, is now in the DPP. We don't know for how long. Lastly, Your Honor, the reason of arrest is now being taken so easy. Why couldn't they do investigation and arrest? Is it today they've realized that they needed to do investigations? The respondent, without us saying that she's guilty or not guilty, we are only saying, for now, this is the person the state brought to the world that they are investigating over the death of Asad. So, Your Honor, what we are saying is that it is them who brought her. It is not the victims who brought her. It is them who suspected her. They have not produced a report to exonerate her. If that report comes here, we'll comply and deal with the consequences. Your Honor, I add that with your many years of experience as a criminal magistrate, you deny this issue, let them be given a mentioned date, let them come and tell us what they have decided. Remember, the Chief Justice said the court shall not be a parking lot for files being brought there and left there. We are urging that let the DPP's office not be a parking lot. We can take a mention date next week. We are alive to the reality that all the prosecutors in this country are in Mombasa for a workshop, the African Prosecutors Workshop. We can take a, if the deciders are in Mombasa, we can take a mention date next week. Let them come and tell us. Either charge it or there is no prosecution of the respondent, then we'll deal with that matter. My good associate, Ms. Kiara, had one issue she wanted to also raise. Your Honor, for stating the obvious law, which anybody knows that the right of audience, either through a victim or an amicus or an office of the court, can address the court on any matter, and that is the right that I'm exercising. Your Honor, one, the state by the police came before you I was only asking whether oral or written has been settled as the oral.
Omari mentioned to this court. But let me start by saying, Your Honor, there are clearly two parties that have a very keen interest in the outcome of these investigations. And those two parties are the family of the deceased person. And we do not trivialize matters pertaining to loss of life. But the second person who has a monumental interest in the outcome of these investigations is none other than my client, who is currently bailed in this matter. And that is why she has continued to offer full cooperation with the investigative authorities. Your Honor, my learned friend has talked of my client as if she's a flight risk. She has nothing to flee from whatsoever. She has not been charged, accused, or in any way put on the spotlight, save for the fact that she's a witness to the circumstances under which the deceased met his death. So would strongly object to use of terms like murder by a senior advocate like Mr. Omari when a matter is under investigation and is pending before the DPP. He used the word murder.
Your Honor, I want to be protected. I have not referred anybody to be the murderer.
No, he used...
I have only put it very clearly that there is somebody dead.
I didn't interrupt him. Yeah. I showed him the courtesy. He used the word murder, not murderer. There's a difference in the dictionary if he checks.
Okay.
He used the word murder, not murderer. He used the word murder. Murder implies someone caused the death of another. Willfully. Whoever that person is. We are today in court with no such evidence. So I'm using the word murder and I'm objecting to the use of such language. PC Kibei has said he's investigated the matter. The DPP is yet to make a decision. As Mr. Omari himself said, as the prosecutor said, let us wait for that decision to be made. As I told the court, my client is ready to continue availing herself to assist with any requirements of the DPP, any requirements of the IO, any requirements of any court that may become seized of this matter in future, if required. What we object to is preemptive strikes. Preemptive strikes by parties who, yes, we understand are grieving. They are grieving. Your Honor, as is my client. As is my client. She lived in the same property with the deceased. So this is not a one-way street, Your Honor. And let us protect the independence. And that is my final point. The independence of this investigation is critical. I have gagged my client, Your Honor, since December 12th from media inquiries for interviews on this matter. Gagged her from talking to anybody apart from the IO on this matter. Gagged her from responding to social media. In the meantime, what has been happening? We see media interviews casting all sorts of imputations against her. How frustrating must it be for her to have to keep quiet and listen to all these statements and judgments going on about her and not to talk? And why is she not talking? To preserve the independence of the investigation being carried out by the lawful authorities. We don't have their statements. We don't have their reports. And she's the respondent to this miscellaneous application. What will anybody else do with the DPP statements or his reports until the DPP says, this is the direction I wish to travel? The rest of us must maintain silence and respect for the independence of that investigation. That's all we can do. And patiently. And let me assure my learned friend, nobody has a deeper interest in the speedy conclusion of this matter than my client, so that she can at least walk out and voice her side of the events that took place, whatever direction the DPP takes. But as of now, she's maintaining absolute silence and allowing them to do their job. Whether they do it in a miscellaneous file or they do it in the DPP's office, Your Honor, this investigation is ongoing. It will not stop until they get to the bottom of how the deceased met his death. And we look forward to that being sooner rather than later. But let's not be policed, supervised, threatened, intimidated, or otherwise coerced by any party. Any party, no matter how aggrieved they may feel, they should allow the law and the legal process to take its course. That's all I wish to state.
On 25th January this year, Your Honor. Your Honor, I'm still waiting for a response from the office of the DPP. And they communicated to me this morning that they have not yet made a decision on the same, Your Honor.
So what do you want us to do with this? Because